Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started. I am keeping the clock this morning to keep you apprised of the passage of time. We've read the briefs and ready to proceed when you are.
Good morning, Your Honors. May it please the court. I'd like to reserve 3 minutes. Your Honors, my clients in this matter.
Counsel, if you could.
Oh, I'm sorry. Attorney John Gill, bar number 0084118. I'm sorry.
It's okay.
My clients in this matter, Louis Buga and David Penjersis, were hired in at the city of Lorain, and at some point in time they were appointed to different positions and given a pay increase, and received correspondence from the appointing authority that they were given a 60-day probationary period. Both of my clients are in a similar position in that they completed those 60-day probationary periods, but within 1 year of being hired, they were eventually terminated by the city of Lorain. And the court's decision with respect to summary judgment and what I believe to be the city of Lorain's ultimate position is that the plaintiffs did not pursue the grievance procedure under the collective bargaining agreement, which basically is a failure to exhaust administrative remedies defense in this. However, I think that it is clear from the evidence before the court that the grievance procedure was not available to them in this case. And if you look at Article 9, Section 19 of the collective bargaining agreement in this matter, it states specifically an employee serving their original probationary period may be terminated at any time and for any reason allowed by law without right of appeal through the grievance procedure contained in this agreement. So the argument of the city is that the employees did not file a grievance, and however, the grievance procedure wasn't available to them. Now, I know that there are other provisions that are conflicting in the collective bargaining agreement that state that employees can request, can file a grievance requesting that the provisions of the collective bargaining agreement be interpreted. However, in this matter specifically, both of my clients received termination letters from the city of Lorain, which are before the court, that said you're being terminated and you have no rights of appeal. You don't have the grievance procedure available to them. So now, after being terminated and receiving notice from the city of Lorain and being told that they don't have any remedies through the grievance procedures, they filed a summary judgment and asked the court to dismiss the matter based on a lack of subject matter jurisdiction for failure to pursue those administrative remedies. And further, in responding to summary judgment, my client submitted an affidavit from the president of their union in this matter, stating that the grievance procedure essentially was not available to them.
Let me ask you a question. Is it your position that, where it says, Article 9, Section 19 states that the probationary period for the original appointment shall be 1 year. So is it your position that because the original appointment was for one particular type of job, they changed over to another job and only had a 60-day probationary period, now we don't have the 1 year anymore?
No, I don't. I mean, the city's position is that even though, well, let me take that in pieces. I believe that clearly they were still within their 1 year of employment. However, the city made representations to them that what appears to be a promotion, which the city does not want to call a promotion, and says that now you're on a 60-day probationary period. I mean, they're still within that 1 year, we're not disputing that. But they made these representations. I mean, I guess the point is, as far as relying on these representations to their detriment, why would the city say you now have a 60-day probationary period unless there was some kind of expectation that upon completing that, there will be some benefit to my clients?
Wouldn't it be that they could continue to stay in that particular position without being moved?
Correct.
Give them 60 days to show that they could do the job before they got shoved off to something else again?
Sure. Sure, I don't dispute that. I mean, they you know, the fact is that though that these representations were made, and they had a sense of security by that, by completing that. And also there's conflicting position or provisions of the collective bargaining agreement that Article 9, Section 20, that the probationary period for promotional appointments and transfers to other bargaining positions will be 60 days. And then if you go to Article 15, Section 3, if the employee performs satisfactorily during that probationary period, the employee shall gain seniority in the classification as of the date he began that probationary period. So there's some sense that once they complete that they have some type of seniority, which would require some type of demotion, is my point.
But you're saying once you achieve that, that means you're no longer in the 1 year probationary period?
No, you are, and that's part of the problem. I don't think it's clear in the collective bargaining agreement. I don't think that there's a clear answer to that question. But, you know, the city's position is that in order to answer that, my clients would have had to file a grievance with the union. And that's ultimately the basis why the court denied or granted summary judgment. But the fact is, you know, they were specifically told in their termination letters that the grievance procedure was not available to them. And also that there's an affidavit from the union president confirming that this was not. So what is their remedy? Well, you know, they can be terminated for any reason other than
during the first year.
During the first year, not allowed by law. So the lawsuit was filed, but the basis of the summary judgment was that they failed to exhaust their administrative remedies. I would also just note that that both of the employees were not given an opportunity to be demoted to their prior positions. Also before this court is the appeal of the summary judgment motion that was filed on behalf of my clients. I would ask that summary judgment motion be granted and that this matter be remanded to the court for purposes of determining damages. Thank you, Your
Honor. Good morning, Attorney Pat Riley from the Appalachia City of Lorain. I think it's clear here that the facts before the court at the trial court level and now before the Court of Appeals were not in dispute. And those facts are recited and I think basically agreed upon by both parties in their presentation of their briefs. What we have here is we have a ruling by the court that subject matter jurisdiction did not vest in them because the matters that were before them is pled through a series of amended complaints by the plaintiffs at the lower court level. Were all dealt with, the issues presented were all dealt with by the CBA, by the collective bargaining agreement. In the collective bargaining agreement, we find the following provisions, Your Honors. First, at Article 2, Section 8, that all matters dealt with in the CBA would not otherwise allow the civil service laws of the state of Ohio to apply. So we have a specific exclusion in the CBA that says the civil service laws of the state of Ohio shall not apply to any matter specifically addressed in the CBA. This is the heart and soul of the court's ruling. Of course, that is a provision in the CBA that mirrors the law that is set forth in 4117.10 of the Ohio Revised Code, the Collective Bargaining Act of Ohio, which says that matters specifically dealt with in the CBA shall not be within the jurisdiction of the State Personnel Board of Review or the local Civil Service Commission. That provision, 4117.10, is carried forward and recited essentially in the same manner in Article 2, Section 8 of this particular CBA, the CBA that was in effect at the time that these two employees were discharged. Well, what matters were dealt with specifically in the CBA, such that the Civil Service Law of Ohio, which is basically the underlying premise of plaintiff's appellant's claim, he says, to digress for a moment, that they should not have been fired because they were promoted and therefore subject to certain provisions in the Ohio Administrative Code could only be demoted after having been promoted. Of course, the law doesn't apply to the Civil Service Law of Ohio because these matters are specifically dealt with in the CBA. But if they weren't, what law is it that he relies upon? Well, both of these men were in their first year of probationary period of 1 year. And I think the court is aware that 124.27 of the Ohio Revised Code says that the appointing authority, in this case of local government, local governmental entity can remove an employee from their position without cause during the first year of their probation. And more importantly than that, that decision is not reviewable administratively or judicially. Essentially, he has his full authority to discharge. If the court were to consider the matter not to be one governed solely by the CBA, as the trial court found, and as I am suggesting to the court here today, you throw them back into the civil service law. The civil service law would provide no remedy to these plaintiffs, to these appellants, because it provides clearly within the first year of their probationary period that the appointing authority can remove them, and that removal is not subject to administrative or judicial review. Beyond that, if you had an opportunity to review the motion for summary judgment filed at the lower court level by the plaintiffs in this case, in there is an admission, a recitation of the administrative code provisions upon which they rely. The first is that once promoted, you cannot be returned, you cannot be discharged, you must be demoted. Now, again, we don't believe the civil service law applies because the CBA expressly excluded it from application to matters specifically set forth in the CBA. But if you take that underlying law to its logical conclusion, he then admits in his motion for summary judgment memorandum that you are not permitted to be promoted during the first year, during the period of your probationary period. So theoretically, the city of Lorain, which is, for the court's information, a statutory city, not a charter city, they could only then operate pursuant to the law of the state of Ohio, had no authority to promote someone who was in their probationary period. That would then throw the rights of these probationary employees back into 124.27. And 124.27 says expressly that they can be dismissed by their appointing authority, and that dismissal is not subject to administrative or judicial review. In other words, if the court were to find that it's a CBA, it does not expressly address both probationary period and job transfers, which it does. If you were to find that to be the case, there is no consequence. Plaintiffs would find themselves in the very same position as they find themselves now, and that would be subject to dismissal during the probationary period. I think it would be unnecessary for the city of Lorain to have demoted them back to their prior position and then within their probationary period dismissed them. I think that's an unnecessary step. As the law director of the city of Lorain, I try to supervise the actions of our city officials and then always ask my opinion, and things are taken. That's why there are orders in this world. This court stands in the same position, looking at the actions of people that may allegedly have been wrongful. Here, the dismissal letters written by the city of Lorain reflected no appeal right to the local civil service commission pursuant to 124.27. Perhaps a better statement would have been made by the appointing authority that they had no appeal right pursuant to what is Article 9, Section 19 of the CBA, which expressly states that during your probationary period, you may be removed for any reason so determined by the appointing authority. I think that's a distinction without a difference and ultimately governs in this circumstance. What else does the CBA provide for? Well, it's Article 9, Section 19, it deals with the probationary period and the right to remove employees during the probationary period. And at Article 15, Section 3, Article 9, Section 20, the job transfer issue. If you are job transferred in Lorain during your employment, you shall be demoted back to your prior position. It doesn't in any way vacate the right of or negate the right of the employer to use his authority pursuant to Article 9, Section 19, which is the probationary period. And finally, the CBA has what is a final binding arbitration provision. And as we state the law, as it's set forth in our brief, if the CBA specifically addresses the issues that are the heart of the gravamen of the plaintiff's complaint and provides for final and binding arbitration, then there is no jurisdiction in the lower court to hear the matter. Essentially what the plaintiffs are saying here is because the union bargained away this individual's rights to contest a removal during the probationary period, that in some way that gives them a remedy outside of the CBA's. And we don't believe that that's the case. I think that's not the law in Ohio. That would not be the consequence if this was a non-bargaining unit employee. You would be subject to 124.27 removal without cause with no right of appeal, administratively or judicially. In other words, as I said before, it would be in no different position than he finds himself today. But beyond that, I think the statement in the case by the court, and this is, I thought, a really neat decision written by a trial court judge up in Toledo, in the case of Russell v. University of Toledo, where he goes through a discussion of what the tenets, the basic tenets of labor law are, and how they may apply to a person who is essentially contending that his rights should not be governed by the CBA. And these are points which, having been lead union counsel for 30 years in this community, I feel are correct in their concept. And what he said in his ruling was as follows. It is well established that the bargaining process in the unionized setting permits the possibility that the interests of individual employees may be subordinated to the collective interests of employees in the bargaining unit. And that's what we have here. We have the union negotiating with its employer and addressing the terms and conditions of the employment of those bargaining unit members, consequence of which is the betterment of the whole is made paramount to that of the individual interests of individual employees. I think that sort of sums up how I view the situation here. As I said in the final statements in my brief to the court, for the court to take a different position, one, I would say would not be supported by the law, and two, if these matters are in fact ones which should be addressed in some manner, the proper place to address them is the bargaining table, not through judicial action. If the union believes that matters involving its probationary employees and them being subject to removal should in some way be dealt with differently than the CBA provides, that matter should be best left to the next session of bargaining between this union and its employer. Thank you for your time this morning. If I have any questions, I'm prepared to address them and answer. Thank you.
Your Honors, I would just note a couple of additional points for the record. I know that it was asserted that the contention of the appellants in this matter, the employees, is that they should have been demoted to their prior position. And that doesn't really sum up the whole argument in this matter. In Section 19, the language designating an employee as being able to be terminated at any time for any reason allowed by law basically turns these employees into at-will employees. And there's other exceptions to the at-will employment doctrine. And they've asserted these. They've asserted that there was an implied contract in this matter, not just that they should have been demoted. I would also note that the case law also provides in this matter, specifically 114 Ohio State 3D 183, that the futility of pursuing the remedies that were available under the CBA would be a question of fact to be determined. Nothing further. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to all sides as well as posted on the Ohio Supreme Court website, which can be linked to through our 9th District Court of Appeals website. Thank you.